Hello, hi, and welcome. So, now the topic that we are going to discuss is what do you mean by a deemed prospectus and explain its related provisions. Students, here the deemed prospectus concept is very important in your examination point of view. So, there are certain documents or circulars or certain advertisements or some information memorandums which are issued by a corporate body for the purpose of offer for sale of securities to the public. So in all such cases under section 25 of the act, the law very clearly states that the document by which the offer for sale to the public is made is deemed to be a prospectus. That was the definition very clearly tells. And there are certain documents which are deemed to be the prospectus. Whenever a company allots or agrees to allot any securities of the company with a view to all or any of those securities being offered for sale to the public, any such document by which the offer for sale to the public is made deemed to be a prospectus issued by the company. And students, here one point is that in case of a prospectus, whatever the rules of law with respect to contents of the prospectus is applicable, the same will be applicable in case of a deemed prospectus also. Not only that, whatever the liability attached in case of a misstatement or omissions in the prospectus, the same liability will be extended if there is any misstatement or omission in case of a deemed prospectus. Hence, any securities were issued through a deemed prospectus, a person by whom the offer is made in respect of misstatements contained in the documents or otherwise will get the same liability like that of a prospectus. The second point says that securities offered for sale to the public. So we call it as OFS, offer for sale of securities to the public. So that is also considered to be a prospectus, which is a deemed prospectus. And here, an offer, if it made for the securities, the sale to the public was made within 6 months after the allotment or agreement to the allotment, or that at the date when the offer was made, the whole consideration to be received by the company in respect of the securities had not been received by it. In all these cases, it is considered to be OFS, offer for sale of securities, Offer for sale of securities to the public is also considered as a deemed prospectus. And here I tell you, offer for sale of securities can be done by a member of a company through the company. See, for example, a shareholder owning, say, 1 crore shares of rupees 10 each in X Limited, if he want to sell some of his holdings to a general public, he can do so through the company. So that is called as a offer for sale of securities by a shareholder through the company. In all such cases, whatever the document that is being issued by the company to sell such shares to the public is considered to be a deemed prospectus. So the effect of section 26 here it is given. Section 26 as applied by section 25 shall have effect as if it required a prospectus to state, in addition to the matters required by that section, to be stated in the prospectus. It is required a prospectus to state. So, it is the prospectus which can state the requirements or the matters what it is required to be disclosed as per section 26. And the net amount of the consideration received or to be received by the company in respect of securities to which the offer relates. And apart from that, the time and place at which the contract where under the said securities have been or to be allotted by the allotted may be inspected. And the person making the offer were persons named in the prospectus as directors of the company. So this is the effect of section 26 in case of a deemed prospectus. And the fourth related provision to the deemed prospectus is persons making an offer is a company or a firm. So which mean to say that here person does not mean an individual. The person here who is making an offer to the public to subscribe for the shares of a company can be a company or a firm. Under section 26 subsection 1 it was clearly stated, and this can be done on behalf of a company or on behalf of an individual or on behalf of partners in the firm as the case may be. Accordingly, all applicable provisions relating to a prospectus like misstatements, contents, civil or criminal liability, etc., are applicable to the said deemed prospectus. There is no dilution of liability for the persons making the offer, which is in addition to the liability of the company whose securities are offered for sale. So no dilution of liability is the highlight here. So you know that there is a liability to a company in case of a misstatement or in case of contravention to the provisions of prospectus, which is ranging from 50,000 rupees to 3 lakhs. And there is also a punishment or a imprisonment punishment to the persons who is behind issue of such a prospectus in contravention to the provisions of the act. If the person is involved, he is liable for an imprisonment up to 3 years or a fine up to rupees 3 lakhs, minimum is 50,000, or sometimes imprisonment and fine both also can be awarded by the court. Here no dilution of liability. In the contravention to the prospectus provisions equally be applicable to the deemed prospectus also. And the last point what it talks about, offer for sale of shares by certain members of a company. So section 28 of the act deals with the offer for sale of securities by certain members of the company. So whenever certain members of the company wants to offer their holdings in a company through the company, so they have to seek the permission of the board of directors to offer so. And in accordance with the provisions of the law in force, a whole or part of the holdings of shares of the public, the company can offer to the public. So in such a case, if any document is being issued by the company to offer the securities to the general public, then that is deemed to be a prospectus. So whenever a company issues any document to sell the shares of members of the company, that also will be considered as a deemed prospectus. So in such a case, the members, whether individuals or body corporates or both, whose shares are proposed to be offered to the public, shall collectively authorize the company. So when a company sells the shares on behalf of the members, whoever is giving up their shares to sell to the general public, shall collectively authorize the company and whose shares are offered, and whatever the expenses that are borne by the company to sell the shares of its members should be reimbursed to the company by these members. And these are the five broad provisions that deals with a deemed prospectus. Dear students, here the point you need to understand in nutshell is that a deemed prospectus is any document which is being issued by a company for offer of securities to the general public. And what it says is that whatever the provisions that are applicable in case of a prospectus will also equally applicable to the prospectus, deemed prospectus also, which mean to say in case of any misstatement or in case of any omissions or in case of any contravention to the provisions of this act, whatever that is applicable to a prospectus equally applicable to a deemed prospectus. And the second point says that securities offered for sale to the public. And here it says that the offer of securities or any of them for sale to the public was made within 6 months after allotment or for consideration. These are the 2 points one has to keep in mind. And the third point is the effect of the section 26, how it is being affected in case of a deemed prospectus. Persons making an offer is a company or a firm. Any person can do so. It need not be the company all the times. And the last point says that for on behalf of the members of the company can sell the shares to the general public. In all such cases, the members, whoever wants to sell their shares, have to consult the board of the directors, and the board of the directors, after taking a decision, they can sell the shares on behalf of the members. And the document which is issued to sell the shares in such a case is deemed to be a prospectus. And here all the members who wants to sell out their shares through company should authorize the company, and at the same time whatever the expenses that company incurs on behalf of these members to sell these shares should be get reimbursed, and the members have to pay to that company all expenses. These are the matters pertaining to the deemed prospectus. And students, the next topic is a simple and very important concept. It is explain the concept related to variation in terms of a contract or objects in prospectus. So variation in object or contract in prospectus was given in section 27. So, dear students, here the point you have to understand is that whenever a company wants to raise a capital, it has to issue a prospectus, and the prospectus should clearly mention the objects for which the capital is being raised from the general public by uh, issue of shares. So it is the objects which makes the investors to take a decision to invest or to subscribe for the shares of the company. So once the company floats the prospectus and raises the money, once the funds are raised through a given prospectus, and if there is any change in the objects, it will be a, then automatically the doctrine of ultra vires will come into picture. So the doctrine of ultra vires says that for whatever the money is being raised, for the same purpose it has to be used. And if there is any variation in the objects due to one or the other reason, the company should give a recall option to the dissenting investors. So deviation to the objects mentioned in the prospectus is not at all permitted. The deviation is not at all permitted. So accordingly, the section states it very clearly the following thing. Whenever there is a variation in the objects, an approval in the general meeting by passing a special resolution is required. So the general meeting is to be convened and a special resolution is to be passed for such a variation. And vary the terms of the contract referred in the prospectus for which the prospectus was issued, except subject to the approval of or except subject to the authority given by the company in general meeting by way of special resolution. So whenever that is to happen, there is a due procedure that is to be followed by the company. So here what it says that a notice in respect of such a resolution to the shareholders must be given, and the notice should be get published in the newspapers. And apart from that, the newspapers should be two newspapers. One newspaper is in English and the other newspaper is in regional language. The regional language means wherever the registered office of the company is situated, whatever the language of the people in that particular area should be the regional language for publishing in newspaper the notice of special resolution to the shareholders. And provided that such a company shall not use any amount raised by it through prospectus for buying, trading or otherwise dealing in equity shares of any other listed company. So this is the condition. Here the company, after publishing the special resolution in the newspaper, and it has to give an exit offer to the dissenting shareholders. Some shareholders may agree to variation of the objects mentioned in the prospectus for which they subscribed the shares of the company, and some of the shareholders may not be willing to continue their investments in the company because of the varying of the objects or the contracts what it was exactly mentioned in the original prospectus. So in such a case, the dissenting shareholders means the shareholders who are not willing or happy for the change of the objects in the prospectus shall be given an opportunity to exit. So they can be paid whatever the amount they contributed to purchase the shares of the company. So this is the compliance mechanism which has been specified by the Securities Board of India. So these regulations are to be complied with whenever there is any change in the objects or contract that was being mentioned in the prospectus. So dear students, you have to understand that whenever there is a company which issued a prospectus, it has to make use of the money which is raised through that prospectus only for the object which is being mentioned in the prospectus. If it is not done so, then automatically the doctrine of ultra vires will get attracted. In such a case, the company has to make a recall option. How they have to process the recall option means, first of all, the change in the object should be ratified by conducting a general meeting and passing a special resolution to that effect. Thereafter, the special resolution should be communicated to all the shareholders by printing that in the newspapers and circulating that both in the English language and the regional language. The regional language is nothing but the language of the people in the area where the registered office of the company is situated. And next is that the company should not make use of the money raised through the prospectus by for buying or trading or otherwise dealing in equity shares of any other listed company. And apart from that, if there are some shareholders who are not happy with the change in the objects to the prospectus, for all those shareholders, the company has to give a exit offer. Thereby, all the shareholders will be paid back their investment in shares. So that has to be complied with in a orderly manner as per the guidelines and regulations prescribed by the Securities Exchange Board of India. So this is the another important and simple topic, and students are likely to be getting a question on this topic, and hence you have to pay required attention to this topic. Thank you, and with this I conclude this session, please.